The next matter before the court is Hangzhou Lijing versus Megalight. As you know, each side will have 15 minutes for oral argument. The appellant can reserve up to 5 minutes for rebuttal. If you wish rebuttal time, let me know, and I will give you a hand signal when you are ready. Thank you. You may proceed.
Thank you, Your Honor. Please the court, I am Alan Medvick. I am here representing the appellants, Megalight and Lijing, and I would reserve 5 minutes for rebuttal. We are here on the appeal of a summary judgment finding against Megalight and Mr. Zhang regarding an alleged $190,000 in debt regarding purchase of the wholesale purchase of light bulbs from the appellee. This was brought we are here based on what was an original purchase order for $270,000 with undisputed payment of $80,000 toward that debt on the purchase order. Plaintiffs moved for summary judgment against my clients, and the ruling from the trial court was confusing. The trial court found that there was a dispute as to the underlying indebtedness of the purchase agreement, that they found a genuine issue of fact regarding the payment of the other $190,000 on the original purchase order.
Did your client receive all the contract?
I don't think there's a dispute that Megalight provided that Megalight received all of the product in dispute. We're not. This is the only issue at dispute is whether
$190,000.
It is $190,000, whether it had been paid, and the trial court found that amount whether that payment had been made was in dispute, that there was a genuine issue of fact to go to trial.
Well, is there a dispute that the 190 was or was not paid, or was the dispute where the money was directed? It was misdirected to a different purchase order or a different account.
And I think that those are, that is the issue at hand here. But under the purchase order and under the trial court's finding, that is an issue to be determined, that whether that payment had actually been applied improperly to some other account or whether it was to have been applied here and was not, is the issue underlying. That is compounded and we're here today because despite that finding that payment may have been made, the trial court went on to find that my clients were in breach of a later repayment agreement and held liable for the $190,000.
If it had already been paid, what's this repayment agreement? Why is there now an agreement?
That is the open question.
Something
and that's
the claim has already been done.
And that's the issue.
Now, when the payment was made, was it designated to go to a certain note number or to a certain bank account, or was it a simple transmission error, or was there neglect in the way in which it was handled?
And that is again an open question at the trial court level. That I believe that our parties believe that money was expressly intended to go to the Megalight debt, and Hangzhou obviously argues differently that they had some discretion as to how that was applied.
But it sounds to me, from reading the briefs, as if the trial court, well, two observations. One is your assignment of error has the feel of, the trial court made inconsistent. It's sort of like inconsistent verdicts. How could it
almost impossible
yes,
to reach the verdict that they did, yes.
Yeah, find an issue of fact on count one, but not on count two. But I don't think it takes into account the fact that these two counts were pled separately, And what needed to be proven was different between one count and the other.
And that would take me to some of the other issues in my assignments of error, that what you're basically arguing is that there may actually be a separate contract, that they're pled as separate contracts. Regardless, we're still dealing with a separate, and we're dealing with one indebtedness, $190,000 that is in dispute and under the purchase order is the same $190,000 that would be in dispute under the purchase agreement. Additionally, that brings us to an issue of consideration for the later contract, that there is no, the purchase agreement is expressly tied into the purchase order. The repayment agreement is expressly tied and expressly references the debt of $190,000 under the purchase order.
But it got it, the time to pay was extended.
I would argue that the time to pay was, there were dates laid out. There's no new consideration on behalf of Hangzhou, on behalf of the plaintiff in that case. I would argue that I think the appellant or the appellee has tried to characterize this as a forbearance agreement. There's no language of forbearance. There's no language that they could not simply have turned around and sued the next day on that case. It was an agreement to set up a repayment plan. It's more in line with an accord and satisfaction without the satisfaction. It would be an unenforceable defense for my side, I admit that agreement I could not, without full execution, an accord and satisfaction is a nullity. It doesn't provide a defense to me, and it allows the other side to pursue the original contract. And I think that's where this stands, that they had a right and they did bring suit under the original contract. They've also tried to separately enforce for the same indebtedness a later contract, which would be for past consideration, which would not be consideration as a matter of law. And I think that's where we are today. And additionally, as I pointed out in the brief, that this issue was not, the issue of this later contract was not presented or defended by my side because it was not put forward in the summary judgment by the appellees. That the motion for summary judgment is expressly relating to the purchase order, the dates relate to the breach of the purchase order, and the repayment agreement and the fact that it was not argued is mentioned only in the reply brief by the plaintiffs, and the trial court, sua sponte, goes on to rule on this repayment agreement after having found that there was no breach of or that there was a dispute under the purchase agreement. Again, I think that compounds the inconsistent ruling with the fact that it was not a properly developed, not a motion for summary judgment, and issued properly before the trial court at that time. These are all concerns on why we're up here today arguing on issues that not fully resolved at the trial level. And we're here because of an impossible verdict where they found a dispute of indebtedness under the one contract but not under the other. I mean, regardless of how you slice the contracts up, there's no separate debt. There's the same $190,000 that was alleged to have been paid and was alleged on the plaintiff's part to have not been paid. So there's that genuine issue of fact that the court found, and that underlies both findings for both the purchase order and the repayment agreement as it stands.
All right, can I interrupt you just for a second?
Please do.
You know, this is an interesting case for me, for all of us, I'm sure, but did you send the Mercedes over there?
I do not believe the Mercedes was delivered.
That's what I thought, okay. So how, I mean, I don't mean to argue with you, Counselor, but, you know, how do
That's
you...
what we do.
The test is, it's a 50, it's a App.No test? I forgot, it's a 56.
We're here on a summary judgment finding it is a de novo review.
De novo review, right, of course. So, you know, obviously you weren't able to convince the trial judge that you had not only did or did not send the Mercedes, but you didn't comply with the original agreement contract you made with this Chinese company.
I would...
If I can, you know, go ahead.
I'm sorry.
Correct me if
I would,
I'm wrong.
I believe that the issue disputed at the trial court level in
Was
terms of,
merchandise,
is that merchandise was delivered and that there is a dispute.
on the
There's an
quality
issue of
of
fact as to whether
merchandise?
payment was made.
Well,
That,
payment made, that should be an easy question. The
And-
merchandise received is a question of whether or not it complied with the original contract to begin with. I'm sorry. Well, it's
That's all right.
already up for time.
He's got his 5 minutes
Jeez.
left. I just-
Okay. I
Thanks.
just, you
Let
can-
me finish this up and I'll go.
Chief, so-
The question of payment was held to be in dispute by the trial court. And so, and that includes, and that's payment by cash, not payment under the repayment agreement. That there was a separate amount of money paid that basically would render the repayment agreement as satisfied because that debt was paid elsewhere. That's the state of the case regarding that.
Okay.
Thank you.
Thank you.
May it please the court, my name is Rod Sanders, and I represent the Hangzhou Lijing Lighting Company. Hangzhou Lijing is a Chinese light bulb manufacturer that did business with 2 different companies. And I think there's a couple things that are important in this case and the facts. And if you bear with me, I think it'll help us out. One is, there were 2 companies. One company in China called Meifang Science and Technology that my client did business with. And at the time of these transactions, was significantly indebted to Hangzhou Lijing for in excess of 2.5 million yuan, which is the Chinese currency. At the time that Megalight contracted with my client, was the existing indebtedness. When the light bulbs, then Megalight orders a series of light bulbs from my client in pursuant to a written purchase order in November of 2010. The payment terms on the purchase order where the balance was to be paid within 45 days rather of the delivery of the final delivery of the light bulbs. We shipped the light bulbs beginning in that same month because Megalight urgently needed the light bulbs. We did that, and then we immediately began invoicing them in November of 2009. After the goods were placed in the containers, shipped and invoiced, was the first time that I'll call one of the disputed Meifang payments came to us from that other debtor. And the form of that payment is significant. It came by wire transfer. It came from a wire transfer, not from a bank account of Megalight. It came from a Chinese bank account of Meifang Science and Technology. There was no accompanying cover letter. There's been no correspondence produced in this case, despite our request, indicating that that payment at the time was intended for the debt of Megalight, as opposed to the significant pre-existing debt of Meifang Science and Technology. So we receive a wire from Meifang Science and Technology's Chinese bank account in Chinese yuan currency. It's wired to our account. Now, when you get one of these wire transfers, it's got me the date of the payment, it has the indication of who it's from, the amount of the funds, and the bank account routing information from the transmitter in the receiving bank. And that it indicated the amount, it indicated the sender as Meifang Science and Technology, not the appellant. And then there's also probably the biggest section on the form. There's a large area that you can write anything you want. You can put, hey, we're sending you this money on behalf of Megalight to apply to Megalight's invoices, and put the invoice numbers and all those things to ensure that that payment will be
How
credited.
much was that? in
I'm sorry?
American dollars?
Oh, the amount of that payment, I believe was $100,000, if I have it right. $100,000 was the first, and then the second payment was $57,000. And those are approximate numbers because of the currency fluctuations.
Or what was your customary practice if you received money without that, I call it the tagline, who it's from and on what purchase agreement or what would you normally do with that? Would you follow up to go back and say, well, why are you sending me this money?
Well, in this case, your question was if it didn't have the sender or the information. In this case, it did have the sender's name on it. Each of the,
It had Medfang.
it had Mayfang Science and Technology. It had no reference to Megalight. And Mayfang Technology, Science and Technology, had a significant debt to us, so we properly took Mayfang's wire transfer and applied it to Mayfang's debt. And after we made that application, there was not subsequently any indication from the defendant that we misapplied the payment until after we instituted the lawsuit. And I'll indicate this to the court. One of the other items, and it's attached as part of our motions, were we issued interrogatories to the defendant. We said, please identify for us the payments you made to us. And the sworn response we received was limited to 2 payments, equaling the undisputed amount of $80,000 that we received. And those payments did not come from a Chinese bank account. Those 2 payments that totaled $80,000 came from a United States bank account, a bank account of Megalight, that were then wired into our account. And the record, and so they indicated in their sworn responses, we've paid you $80,000. And then some point in time later, they kind of changed their tune on that. And in addition to giving us the $80,000 sworn interrogatory response, they gave us, or produced their QuickBooks reports of their payouts to my client. And just like the response, it said that they paid $80,000. Then after they were faced with a summary judgment motion, they come up with the Mayfang payments and claim that the Mayfang payments somehow were intended to be Megalight's.
Well, then why didn't somebody move that Mayfang be a party to the lawsuit?
It's a Chinese part, the transaction between Mayfang and my client is purely a Chinese transaction.
So we don't have jurisdiction on it?
Correct. However, the interesting snippet is that the owner of Megalight, who's defendant Dylan Zhang, is also a part owner of the Mayfang Company. And the Mayfang Company, while this litigation was in its infancy, my client sued Mayfang and Mr. Zhang on the Mayfang debt in China. Excuse me. They received a judgment, and Mayfang was credited with the payment, which is owned by Mr. Zhang, was credited with the payments towards Mayfang that he now wants to get credit for a second time in a second lawsuit.
Still pending?
That's this case.
Oh, okay.
The Chinese case is completed, final, unappealed.
And what was the amount that Mayfang was credited with?
It would credit approximately, again, somewhere between $187,000 and $190,000, depending on what the currency exchange rate.
Whereas the original said 157.
Well, there was one additional payment later that also came in, I'm sorry, of another 30, roughly 30. And that was in May 10th of 2010. So as of May 10, 2010, each of these alleged Mayfang payments had already occurred. The undisputed $80,000 payments had occurred. But what's interesting, at that point in time, my client obviously is quite upset because he hasn't been paid the remaining $190,000. They contact the defendant, and then the defendant has some email communications with my client where he acknowledges the debt. And then not only does he acknowledge the debt, he makes various proposals on how he's going to pay it off.
He being who?
Mr. Zhang and Megalight. He says, well, I would like to do it, and he has some different proposals that don't meet with my client's approval. And then eventually, in November of 2010, after all of the payments that are either disputed or undisputed payments, however you want to refer to them, they've already all occurred. That's when they enter into the payment agreement. What the payment agreement essentially is, it's a settlement agreement between the parties. They agreed that, hey, you owe us this $190,000. He acknowledged it, and then it would be entitled to interest back from the time of shipment.
did he personally guarantee some portion of that?
As a condition of the settlement agreement, he became personally obligated.
And I guess there's a question as to whether he became personally obligated to the portion that involved the surrender of the vehicle of $45,000, or was it the entire, it's really, the language is not clear.
It is unclear, but it's a little easier for our purposes on appeal today because the court allocated him $45,000 of personal liability, and that's not on appeal or disputed. My client's just, our primary defendant will be Megalight for the balance, but in that settlement agreement that they call a payment agreement, the parties altered the performances, just like you would do any other settlement agreement. My client, originally the money was due in January of 2010. They enter into the agreement in June of 2010, and my client grants additional time until sometime late in October of 2010 for the defendants to be able to pay off the amounts required in the payment agreement. They also alter the performance. Instead of requiring a pure cash payment, they allow him to pay the $45,000 plus provide an in-kind payment through a motor vehicle that they were going to deliver to my client. After they entered that agreement, at no time was there any evidence indicating that they ever paid $45,000 afterwards, and there was never any evidence that they delivered the motor vehicle on him. So what happens is they run into this problem. Eventually my client files suit, and the other performance issue, alteration item, I think that was in there, there was time, there was the item of performance, and then we also gave them the ability to avoid paying interest. So they could have, if they would have all used the terms that were in the party settlement, they could have eliminated the accruing of interest altogether by paying their performance within, there was a deadline slightly before, the full payment deadline that they paid early. They could get the opportunity to avoid all interest. So my client did, give consideration, unquestionably, for the settlement agreement. The other part,
Is this common practice in the countries?
I think that sometimes when you
I find it very strange, that you would give a car, I'd say maybe pay 50,000, but in Chinese money it would be worth 190 or.
I think some of it has to do with the difficulty of getting the vehicle to
Over there?
there.
They can't buy Mercedes from Germany?
I don't know. There was, I don't know the motivation, but there was some motivation that my client was willing to take a car, which may have been worth less than 190. So my client potentially gave additional consideration in the form of reduced value, in that, as you identified, a car that probably wasn't worth $150,000. They accepted that as
It
a
might have been
compromise.
worth that much in China.
I don't know. That wasn't developed in the case.
I don't know.
But on appeal, the appellants mainly argue two things. Their brief boils down to, one, a contention that the court granted judgment sua sponte, and two, that there was a lack of consideration. We talked about the consideration that they definitely received as part of the party settlement. The other argument that undercuts their assertion is the lack of consideration is an affirmative defense. The Ohio State Supreme Court has been clear in the last couple of years, if you don't put an affirmative defense in the pleadings, you've waived it. In this case, their answer does not contain any mention of any affirmative defenses or anywhere that they're contending there was a lack of consideration. If they didn't waive the lack of consideration defense that they're asserting at that point in time, they waived it in the trial court by not asserting it at all. They didn't raise it on summary judgment. They didn't raise it even in their motions for reconsideration. The record is devoid of any reference to lack of consideration. They've waived the arguments they're trying to present to the court today.
You have a little over a minute back.
Addressing basically the sua sponte, we raised it in the motion. In the statement of facts, we recite the formation, the performance, and their breach of the repayment agreement, and we also asked for judgment. Clearly, it was placed on the table. It was identified. They chose not to respond to that issue. The only other issue is for the alternative grounds of relief in this case, even if we took these payment items and set them aside from the law, the existing law on when you have a situation where there's an unclear payment, the duty is on the person sending the check to specify how it is to be applied if it was in any other manner. There's no question that the check did not have that any type of specificity, so it granted us the discretion to apply it how we deemed appropriate. We applied it to the person whose name was on the check. The only other issue for this was one of appeal today is the court failed to grant us prejudgment interest on our contract claim. It's clearly an abuse of discretion. As a matter of law, it's automatic. It doesn't matter because this court's recognized in its opinions. Once the motion's filed, it doesn't matter if the order granting the judgment is final or non-appealable at that point in time. The judgment interest begins to accrue in the plaintiff's order. So thank you for your time today.
Thank you.
Thank you. As to the characterization of the payment agreement as a settlement agreement, it's just not. The language
Why not?
is much more in agreement, much more in line with an accord and satisfaction agreement, an attempt to satisfy a disputed debt. It is, as has been characterized, there is no new consideration. There was no pending lawsuit from which this could be settled. There's no language in the agreement that they would not pursue lawsuit under the original debt. In fact, they did pursue lawsuit under the original debt. That the language basically states that they've reached an agreement on the debt. And again, I don't know what the limitations of the translation are, but I have what's in front of me that says the parties A and B have reached an agreement regarding the debt. That's a debt in dispute, and they found an alternative payment to resolve the case. That would be in accord. If the parties if my side had satisfied that agreement, provided the money and the vehicle, that would have been satisfaction. That would have been a bar to the prior contract. An accord without satisfaction is not a bar to that prior contract, and Hangzhou is free to and did sue under that original agreement. That is the state of the law, and I believe that that's what this agreement is a written accord that was to be satisfied, and as such is an executory contract that doesn't take effect until it is fully executed. Regarding the description of the payments, this is what the trial court found to be in dispute. These payments that went to the plaintiffs from Mei Feng, which were close in time and approximately equivalent in value for the value outstanding for the $190,000, were paid and were under the belief of my client and by affidavit testimony were intended to satisfy this debt. That is where the trial court found a genuine issue of fact regarding whether the purchase order had been satisfied. With that would also satisfy the debt under the payment agreement regarding, there could be no other satisfaction. There's not a separate 190 that would need to be paid. I don't think I would be surprised if Hangzhou is here looking to recover both the 190 and the car and the 45. That would not be my expectation.
They'd probably take it if possible.
I would expect they would.
They take the car first.
They take all of them. But that said, and the other aspect of this and regarding, in particular, the money owed by Dylan Zhang, that personal guarantee contained therein, as I mentioned in my brief, is without consideration. He obviously was not a party to the original agreement. He is receiving no benefit at all personally from this. He's not, all he has done is offer to provide money under this accord, and that for him to be obligated based on that is without consideration, I think, unenforceable.
What about the fact that he has an interest in the company?
He was not engaged in the original contract personally. He was not originally indebted or personally guaranteed. The original agreement, that was signed by a different officer of the company, Tiffany's son, and signed solely in her capacity as an officer of the company. The agreement, the original purchase order for the light bulbs has no personal guarantee for Mr. Zhang. He receives no personal benefit and was under no personal obligation under the original contract. There's no new consideration, there's no new light bulbs, there's no new delivery, particularly toward him. There's no consideration to be had for Mr. Zhang's guarantee. There was nothing offered and there was nothing received. So to that end, particularly against him personally, there's not even, I don't believe there's a genuine issue of fact. I think it's pretty clear that he is not liable under the repayment agreement.
And with that, you're out of time.
Thank you.
Thank you. We will take the case under advisement, send you a copy of the opinion when it's issued, and of course you can monitor our webpage and maybe catch it before we can send it to you. Thank you very much. Have a good day.